Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So if you were with me last week, you know that we had a pretty big update in Duncan v. Bonta. Duncan is a case that challenges California's ban on magazines that can hold more than 10 rounds. This particular case has been going on for the past almost 10 years now. It's gone through the process multiple times. It's already been up to the Supreme Court once, where it was GVR'd post-Bruin. Now, last week I mentioned that it was going to be headed up to the Supreme Court this week. Well, unfortunately, there's been some changes, and we need to talk about those changes today and kind of what they mean for this case. So let's get to it. Now, real quick before we get started, this channel is proudly sponsored by Attorneys on Retainer, who is backed by Attorneys for Freedom, the only law firm in the entire country that does nothing but self-defense cases. If you are somebody who carries to defend yourself or your loved ones, or maybe you just keep something in your home for home defense, having an Attorneys on Retainer membership in your back pocket is like having an attorney in your back pocket. Because heaven forbid the worst happen and you defend yourself, you could still be the one that ends up in handcuffs. With that membership, you call the number on the back of the card, you speak to an actual attorney, giving you instant attorney-client privilege, and they will be there to defend you through the entire process. And that includes up to $100,000 in civil liability coverage. They have red flag coverage, online education and training, and so much more. So check out the link down below. I have some codes down there as well. And they have several different types of plans that come in at different price points. So something for everybody's budget. Again, check out the link down below and get yourself a membership to Attorneys on Retainer. Okay, so let's go ahead and talk about what's going on here with Duncan v. Bonta. And for those of you who are not aware, because this case is about to receive national attention, Duncan is probably the best chance that we have ever had to get a magazine ban case before the Supreme Court. And that's because this case is complete. It's been decided on the merits. As a matter of fact, it's been decided twice. It's been up to the Supreme Court, who then kicked it back down to the Ninth Circuit after Bruin. It went back down to the district court level, went all the way through the process, and then once again, the en banc panel of the Ninth Circuit Court of Appeals found that the ban was constitutional. Now, they say it was constitutional because, well, anything more than 10 rounds is just considered an accessory. Now, I don't know who came up with that stupid arbitrary 10-round number and who decided that once you put that 11th in there, somehow it becomes an accessory and not necessary to the overall function of the arm, and who just decided to ignore the common use test. But that's what the Ninth Circuit does, and they decided to uphold California's ban. Well, that means that this case is now going up to the Supreme Court. It was going to be going up to the Supreme Court this week, but there have been some changes. Those changes are because of recent decisions by the Supreme Court. Obviously, we know that since Duncan was decided by the 9th, we saw that Snope was denied, Ocean State Tactical was denied, and we also have the decision in Smith & Wesson v. Mexico. All of those things have to be considered before the CRPA decides that they want to file their petition for a writ of certiorari to the Supreme Court to have them hear this case. So basically, here's what's going on. The CRPA, who brought this lawsuit, Michelle & Associates, which is the law firm that represents the CRPA, decided that they wanted more time to gather as much information as possible from these more recent Supreme Court decisions that could potentially help Duncan. And there was a lot of language that could help Duncan. As a matter of fact, Justice Kagan in the Smith & Wesson v. Mexico case basically confirmed common use for, ARs. You had Justice Kavanaugh, who also confirmed common use in the denial for Snope. I mean, there was a lot. And so they wanted to make sure that they could add as much of that in their petition before filing it. So what they did was they asked the Supreme Court for an extension. Originally, the extension they had to file by this month, but this extension now allows them to file by July 18th. So instead of it going up this week, they now have until July 18th to file their petition with the Supreme Court. But that's good news because, again, there was a lot of great language that I think is going to not only help this case be accepted by the Supreme Court, and I know there's a lot of people out there that are just rolling their eyes and probably don't believe it, but a lot of information I think will help get this in front of the Supreme Court, and I think also information that will help us win this case. Now, one of the big arguments in Duncan is that magazines that can hold more than 10 rounds are in common use across the country, including in California, for lawful purposes. And it doesn't have to be for self-defense. But if we take a look at the denial in Snope, even Justice Kavanaugh says, in the District of Columbia v. Heller, this court ruled that the Second Amendment must be interpreted in light of constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because handguns are in common use by law-abiding citizens, this court held that the District of Columbia's ban on handguns violated the Second Amendment. This court's later Second Amendment decisions in Bruin and Rahimi did not disturb that historically based common use test with respect to the possession of particular weapons. And we all know that magazines are arms. So again, it's recent language from Kagan, from Kavanaugh, from Thomas. All of these things will help Duncan in the end. So I'm happy that they decided to wait and they decided to make sure they got all of this information into their petition before they filed it. This is going to help us out in a huge way. Now, for people that are looking for a timeline, even if for some reason, let's say that they get it in right by July, it's probably not going to start conferencing, which is where the Supreme Court justices get together and determine what they're going to do with the case, probably until late 2025, if not into 2026. And then they will have to hear oral arguments and go through that process. So the chances are we're not going to find out a decision in this, even if the Supreme Court takes it, until maybe middle of next year. So we'll see what happens. But again, we still have some time, and it looks like we have a really good chance here. So we're going to continue to follow this case, and if there's any more updates, I will let you guys know. But I am really excited to read the petition that is filed by the CRPA to the Supreme Court. When that comes out, I'll let you guys know about it. Thank you all very much for watching. I really do appreciate it. If you haven't done so already, make sure you hit that subscribe button, and you guys have a great day.